The benefits of having a mobile home office is that if it gets a little too hot or I need a little more light, I just need to pop the hood on the office. Bada bing, bada boom, more light and more air. Viva Frei, former Montreal litigator turned current Florida rumbler in my home office, and I've been meaning to cover this story to give the update in the New York Alvin Bragg, corrupt Judge Juan Marchand, Donald Trump persecution, but I've been a little distracted by the DNC, the demonic national convention, which is going on this week. Luckily, it comes to a close today so we can get back to more important things, such as the New York persecution conducted by the Soros-Funded Alvin Bragg before the totally corrupt Judge Juan Marchand, whose daughter works for Authentic HQ and has been raking in money hand over fist, working with the Kamala Harris campaign. There's been an update in that case as relates to the sentencing that is scheduled to happen early September. I am not doing a recap for anybody who doesn't know what's going on, except to say that it is the case, the hush money payment, where Trump was charged with felony charges that were bumped up from what would otherwise be, in the worst case scenario, a simple misdemeanor, mischaracterizing or misdescribing an entry in the books as relates to an alleged hush money payment to Stormy Daniels, yada, yada, yada. You know what it was. It was referring to the hush money payment as legal services in the entries of the book, in the checks that were paid to, what's that guy's name? The slimy Michael Cohen. And they basically charged Trump with 4 felonies a month for like 6 months, because every month he would write the check, write the ledgers, sign the check. It's a joke. It's a joke. At worst, it would have been a misdemeanor, but they found a way to bump it up to a felony. Then they found a way to convict Donald Trump on 34 counts of this bogus felony so that they could run around for however months they ran around for calling Trump a convicted felon, as they're still doing. Now, he was convicted by this corrupt court system in New York. Pack your stuff, get the hell out of New York State. He was convicted in New York State, and the sentencing had yet to occur. But in the interim of the conviction and before the sentencing, the Supreme Court came down with this minorly significant ruling on the immunity issue, ruling that presidents benefit from presidential immunity for constitutional acts they carry out as president. They do not benefit from immunity for purely personal acts, and there's basically a presumption of immunity for anything falling within the ambit of presidential acts. And in order to figure out where the act fits within this spectrum of conduct, you need to have something of an analysis in order to determine whether or not it's officially a presidential act, officially a personal act, or somewhere in between. Set that aside. It's not just that they came to that ruling on immunity. They came to an important ruling on the admissibility of evidence, and they determined that immunity or not, it would be inadmissible to allow as evidence correspondence that were clearly within the parameters of presidential conduct. Why is that relevant? Well, there is arguably an issue as to whether or not immunity applies in the New York case, because all of the charges for which Trump was convicted occurred while he was president. So you might not think that these were official presidential acts, but there's still a debate to be had because all of the conduct in question was when Trump was president. There's also the issue as to the admissibility of evidence that was definitively within the presidential realm of conduct that ought not be allowed in virtue of the Supreme Court ruling on immunity, and as a result of that, there was a postponement of the sentencing, and now Trump has asked that it be postponed a second time because there's going to be appellate issues as relates to the admissibility of the evidence and whether or not they even vacate the conviction to begin with. There are 2 letters at issue here, one from the Trump camp and one from Alvin Bragg, which all but submits to the request from Donald Trump. From Blanche Law, August 14, 2024, Dear Justice Marchand, the court should adjourn any sentencing in this case. The one should not be necessary because dismissal and vacatur of the jury's verdicts are required based on presidential immunity until after the 2024 presidential election. We respectfully submit this pre-motion letter seeking that adjournment relief pursuant to CPL, etc., which can be deemed the motion. Now, just to pause there for a moment, I have made my prediction. I think this conviction is getting vacated, and I think the judge is going to have to say, oh, my hands are tied by this extreme Supreme Court ruling. I've got to now send this back. We've got to have evidentiary hearings on what's admissible as evidence. We've got to determine what Trump can even be charged with if it is a presidential act, and so I have no choice in the matter. I've got to vacate this conviction, and we've got to start from scratch. If it were up to me, I would have sentenced Trump to jail, but the Supreme Court has tied my hands, and it's all their fault. That's my prediction. Others have predicted a conviction, and others have predicted jail time as a sentence. I think they're wrong. We'll see what happens. I don't even think we're getting there, but let's get to the second paragraph of this letter, because it's a beauty. Notwithstanding the court's ruling on the disputed recusal issue, the requested adjournment would prospectively mitigate the asserted conflicts and appearances of impropriety, which are also also the subject of an ongoing congressional inquiry. In yesterday's ruling, the court did not address the significance of the 2019 conversations with Your Honor's daughter criticizing President Trump's use of Twitter, with the new fact being that existing tweets from President Trump at the time of that conversation are squarely at issue in the pending presidential immunity motion. Moreover, since the recent recusal motion, as Kamala Harris did previously, Tim Walz wrongly referred to this case in a public speech as the Democrat Party's nominee for vice president. In that same time frame, Michael Nellis, a business partner of Your Honor's daughter at Authentic Campaigns and Authentic's founder, posted on social media about inter alia making maximum donations to the Harris campaign and using his clout with that campaign to get Walz to, quote, talk on our white dudes for Harris call last week, end quote. Sentencing is currently scheduled to occur after the commencement of early voting in the presidential election. By adjourning the sentencing until after the election, which is of paramount importance to the entire nation, including tens of millions of people who do not share the views of Authentics, its executives, and its clients, the court would reduce, even if not eliminate, issues regarding the integrity of any future proceedings. So you get the idea of the basis of Trump's request of the postponement of the sentencing, and you've had the judge in this case already postpone the sentencing to September, if there would be any sentencing. This is the judge's own word, the corrupt Judge Juan Marchal, whose daughter works for Authentic, that is raising money off of this and working with the Kamala Harris campaign. You get the idea for the request for the adjournment, and what does Alvin Bragg have to say in response? They basically give up and say, Your Honor, do whatever you want. We're not going to contest it. We defer to your better judgment, because they know that Trump is right. District Attorney, County of New York. Dear Justice Marchand, this letter addresses defendant's August 14, 2024 letter requesting an adjournment of the sentencing date. The people defer to the court on the appropriate post-trial schedule that allows for adequate time to adjudicate defendant's CPL section whatever motion, while also pronouncing sentence, quote, without unreasonable delay, end quote. To assist the court, we note the following points. So Bragg, Colangelo, whoever the heck wrote this letter, and I think it was Colangelo, but the Bragg office is basically giving up and saying, yeah, we know Trump is right. Your Honor, we defer to your better judgment. Adjourn if you deem fit, as the judge should. But then they have to add some self-serving, totally inaccurate statements, as we shall see in the second paragraph. Defendant's letter indicates for the first time his intent to seek interlocutory state or federal appellate review before he is sentenced of any adverse ruling on his CPL section 330.30 motion. It is correct that the denial of immunity from prosecution is immediately appealable. But here, in contrast to defendant's criminal case in D.C., the question of defendant's immunity from prosecution is not presented. The only question now before the court is whether a small subset of the trial evidence was improperly admitted in light of a brand new evidentiary rule that derives from official acts immunity, and if so, whether any error in admitting official acts evidence was harmless. Just a small subset of evidence that was improperly adduced in light of the Supreme Court ruling, and it was harmless in any case. That's why they adduced it as evidence. Do you understand what these scoundrels are trying to do? Yeah, we had some impermissible evidence as per the Supreme Court ruling on what evidence would not be allowed based on the fact that it was evidence derived from presidential official conduct. Yeah, there was some that might have snuck its way in, but it was totally harmless. If you adduced the evidence, it was because it wasn't harmless. It was because it was relevant, and now they're trying to downplay the impact of what they've done that needs to be reviewed by acknowledging it, but basically saying it's not worth anything. The Supreme Court's recent decision did not consider whether a trial court's ruling on that distinct evidentiary question is immediately appealable, and there are strong reasons why it should not be. Nonetheless, given the defense's newly stated position, we defer to the court on whether an adjournment is warranted to allow for orderly appellate litigation of that question, or to reduce the risk of a disruptive stay from an appellate court pending consideration of that question. The people are prepared to appear for sentencing on any future date the court sets. It really is amazing. They try to downplay the fact that they know, that they admit that they have evidence that would not be admissible under the Supreme Court ruling. They try to downplay the importance of that, and then they try to pretend that Trump wasn't going to appeal this necessarily in light of the Supreme Court ruling on immunity. They are dirty, rotten scoundrels, and not in the good sense of the word, as in the Steve Martin movie, which was a classic. They are dirty, rotten scoundrels.
Why is the cork on the fork?
To prevent him hurting himself and others.
The rest of the letter is more or less important, except you gotta love the last paragraph of self-serving, patting themselves on the back. They are such good prosecutors. Finally, defendants' apparent insinuation that state prosecutors are incapable of applying federal constitutional law is fundamentally flawed, given that the people and this court protect and apply federal constitutional rights every day. By the way, if you haven't yet done it, make sure that you give this video a thumbs up, drop a comment, and make sure that you are subscribed and that you have notifications turned on. And there, I got you to listen to that that before I end this vlog. That is a vlog. If you like what I do, you know what to do. I've made my prediction. I think the judge is going to wash his hands of all of this, blame it on the Supreme Court. They got their convicted felon in as much as they thought it would be useful, but it turned out to be totally counterproductive. I do not see Judge Juan Marchand sentencing Trump to jail, let alone sending him there. I think what I think. I've made my prediction. It's out there. I can never take it back. And you will know who makes the best predictions based on what happens based on the predictions. But you know my reasoning for it. And now you know the vlog, I guess. Get out there, exercise, eat healthy, sunlight, talk to people in real life. And yes, now you know your vlog. Peace out, peeps. Booyah.
Hello, everyone. Liberal billionaires who absolutely hate our country, and hate it they must, because they've given $250 million to Kamala Harris, who was adjudged to be the worst vice president in the history of our country. Think of it, considered the worst vice president we've ever had. Now she's running for president. Now remember this, she wasn't going to, and they stole it from Biden. He had his 14 million votes, it was all done. He didn't do well in the debate, to put it mildly, and they said, let's get somebody else, and she ended up getting it without a single vote. She didn't get one single vote, and now they're putting her up. They're trying to load it up with cash from unions and everybody else, and we have a fight, and I think we're going to do well in the fight. If we don't, we're not going to have a nation. So only if you can do it, if you can afford it, good, and if you can't, we're going to win one way or the other, because we have to win. We're not going to have a country left otherwise. So I want to thank you all. If you can do it, do it. If you can't do it, or if it's going to be even tight, if it's going to make you a little bit tight, don't do it. We will win. We'll see you at the White House. Thank you.